Hello and welcome to Spardha Lines, your one-stop destination for all the civil services examination like UPSC, KPSC and SSC. Let us try and understand some of the important topics that have been in news for today, that is 8th of August. First, let's look into the first article. The first article that we have is in reference to the Delhi Service Bill. Let us try and understand what is this article in greater detail. First, we have to understand the context. What is the context? We have the Government of India which has introduced the Delhi Services Bill. What is this bill all about? What are the various contentions? What are the drawbacks with this particular bill? How is going to impact the larger legislative business of Delhi is what we will try and understand with respect to this article. First, let's look into the background. We know for the fact that Delhi happens to be one of the unique union territories. Why? That is because it is unlike any other union territory like Chandigarh or Daman and Diu, so on and so forth. When it comes to national capital Delhi, what we have is the union territory which also has the legislature as well. So we have the Lieutenant Governor who happens to be the administrator. In addition to the Lieutenant Governor, what we have is the legislature. So people go up and also select their legislators in that particular area. So Delhi not only has an administrator like other union territories, but it also has the legislature as well. So we have the people who go up to their constituencies, vote for their representatives. So ultimately what we have is the legislature. So Delhi happens to be one of the unique union territories. As part of the assignment, you have to put on the comment section which are the other union territories which you can see which has the legislature. So what exactly happens when you look into the Constitution of India? Delhi has a unique status. That is because we have one of the important articles in the Indian Constitution called as Article 239AA, inserted into the Constitution by the 69th Amendment Act of 1991. Remember, this can be very important from the preliminary examination point of view, where Article 239AA conferred special status on Delhi following the recommendations of S. Balakrishna Committee that was set up in 1987 to look into Delhi's demands for statehood. So what are the two important pointers from the preliminary examination point of view? One, it was inserted into the Constitution by the 69th Amendment Act of 1991, and at the same time it was on the basis of the recommendation of S. Balakrishna Committee. These two important pointers are very important from the preliminary examination point of view. According to this provision, the NCT of Delhi will have an administrator and a legislative assembly. So what they will have? They will have an administrator in the form of Lieutenant Governor, and what they will also have is a legislative assembly where people go up and also select and elect their representatives. Subject to the provisions of the Constitution, the legislative assembly shall have the power to make laws for the whole or any part of the NCT with respect to any of the matters listed in the state list or concurrent list insofar as any subject matter is applicable to the union territories. They would be able to legislate on all the matters that are present in the state list as well as in the concurrent list. But there are three areas or three legislative businesses that they will not be able to legislate on. One is with respect to the police, the second happens to be the public order, third happens to be land. So it is in this particular backdrop that they would be able to legislate on all areas, but these areas like police, public order and land will immediately fall under the domain of the central government. Now you might ask me a question, why is that the police, the public order and land is given to the parliament? It is they who would be able to legislate. Central government has a massive power when it comes to these areas of legislative business. That is because Delhi is not like any other union territory. Delhi is the national capital. You have number of international organizations. You have embassies as well. It is the national capital of the country. So police have to be under the control of the central government so that they are able to control the law and order in the national capital region. As a result, these three areas come under the central government, but rest of the other areas, it is where the state government would be able to conduct their legislative business. But there has been a lot of controversies with respect to Article 239AA. These controversies is because you have one party at the central government represented by the BJP, and you also have the AAP represented at the state level. So obviously there will be power tussles as well. There will be issues between both the political parties. One party may not allow the other party to function. This is the rules of how generally the political parties work when it comes to their areas of expertise, especially at the state level as well as the central level. But what happens in this particular case, since there is a lot of tussle, they ultimately go to the Supreme Court of India. The tussle is whether the lieutenant governors has the maximum power or it is the legislative assembly which has the maximum power. Who has the power? Why? That is because for all the issues that have been taken up, all the issues that have been discussed, for all the legislative businesses that the state government is coming with, the state government feels that it is the lieutenant governor who is not allowing them to work. So it is in this particular backdrop, they go to the Supreme Court of India where two times. One is in 2018, the other happens to be in 2023, and these issues have been dealt by the Supreme Court of India. So what did the Supreme Court of India say? The Supreme Court of India looked into this particular issue and ultimately went on to say that all the areas of legislative business can be initiated, propelled, and ultimately the legislative business can be carried out by the elected representatives, legislative assembly. So in this particular backdrop, they also go on to say that the lieutenant governor will have to listen to the aid and advice of the council of ministers. That is, you have the cabinet, you have the council of ministers. These council of ministers, whatever they suggest, this has to be listened, this has to be accorded, this has to be forwarded by the lieutenant governor. So the lieutenant governor, in case he has any issues whatsoever, in case he has any differences between the council of ministers, in that case what they have to do is refer the same to the President of India, and the President of India will ultimately decide what decision has to be taken. So in the majority ruling in 2018, the constitution bench held, although Delhi could not be accorded the state of a status, the concept of federalism would still apply to it, adding that centre has exclusive executive power with respect to Delhi over its police, land and public order. The court clarified that with respect to other matters, executive power is to be exercised by the government of NCT of Delhi. So in all areas, it is the state government which should be able to make the laws, but with respect to police, land and public order, it is the central government which should be able to law. So in 2023, once again, the Supreme Court reclassified this, and with respect to the services as well. What do we understand by services? Let's say, for example, we have the civil services, we have the Group A officers. These are the Group A officers who look into the administration of that particular state. There was also a power tussle between the lieutenant governor, that is who is representing the central government, and we also have the state governments as well, who will have control over the services, which means who will have control over the operations of these people, who will be able to transfer them, who will be able to dismiss them, who will decide it. The Supreme Court in 2023 once again clarified this power would be ultimately lying with the central government. This power will be ultimately lying with the state government, and central government will have to concur with it, which means the lieutenant governor will have to concur with it. That means that he has to listen to the Delhi government. Because of this particular order passed by the Supreme Court, what the central government did, it came up with an ordinance. This particular ordinance wanted to make sure it came up with legislative overruling. Let me give you an elaborate explanation of what is this legislative overruling. What happens in legislative overruling? Let me give you an example. We have the Supreme Court of India. The Supreme Court of India has passed an order. It has passed a judgment. So this particular judgment may not be appreciable for the central government. So what does it do? It issues a bill and it reworks on this particular order passed by the Supreme Court. For example, in the year 2018, there was a judgment that was passed by the Supreme Court of India with respect to the SC/ST Act of 1989. What did the Supreme Court say? The Supreme Court went on to say that whenever there has been an allegation made against a person with respect to the SC/ST, so I am a person who has committed a crime by abusing one of the persons from the SC/ST community. Let's assume for a moment that it is so. So prima facie, without even looking into it, the present law says that this person, that is me, I have to get arrested and I'll be thrown behind bars. And this also happens to be a non-bailable offense as well. So in this particular case, the Supreme Court came up and said that in case there is an atrocity case, the police officers prima facie cannot arrest, but instead they have to do an investigation with respect to this particular order issued by the Supreme Court. What did the central government do? The central government came up with a amendment and they said that the police officers need not look into it prima facie. They have to arrest first and then conduct the investigation. So this is what is called as legislative overruling. So there would be an order, there would be a judgment that would be passed by the Supreme Court of India, but when the central government feels that this is not right, they can make amends with respect to Article 368, and that is what is called as legislative ruling. So in this particular case, what we have is Supreme Court which had passed an order that all the powers will be with respect to the state government, all the powers with respect to the services will rely with the state government, but despite passing this particular order, the state government issued an ordinance, and that ordinance is now eventually turning into a bill, and if passed by the parliament, it will also become an act as well. This is what is called as legislative overruling. An order passed by the Supreme Court will be overruled by the legislature by passing a bill, and when assent is given to it, it eventually goes on to become an act. Even in the present situation, what we witness is called as the legislative overruling. Now let's look at what has happened with respect to this legislation. So what has the government done? There was an ordinance. This ordinance is replaced by a bill, and this bill is what is called as Government of National Capital Territory of Delhi Amendment Bill of 2023. What does it want to do? It wants to ensure that it comes up with changes to the Government of National Capital Territory of Delhi Act of 1991. So basically, as of now, when we look into this particular act, it regulates what are the powers of the Lieutenant Governor, what are the powers of the State Assembly. So this will be regulated under this particular legislation. So basically, the Government of National Capital Territory of Delhi Amendment Bill of 2023 tends to amend Government of National Capital Territory of Delhi Act of 1991. Under this particular bill that is proposed by the government, when it is passed in the Rajya Sabha and ultimately in the parliament, it becomes an act as well. One of the important pointers that we have to look at is the establishment of National Capital Civil Services Authority. Under this particular bill, what we will have is an authority. It is this particular authority which will look into the transfers of the administrative powers of the services people. What do we understand by this? We have the, let's say we have the officers who work for the administration of Delhi. It can be Group A officers, it can be Group B officers. Who will hold control of them? Who will suspend them temporarily? Who will impose penalty on them? Ultimately, these recommendations will be decided by the National Capital Civil Services Authority. So when we speak about this National Capital Civil Services Authority, there are three people involved in this particular authority. Who are those? One, what we have is the Chief Minister, who happens to be an ex officio member, followed by what we have is the Principal Secretary to the Home Ministry, and ultimately what we will also have is the Chief Secretary of Delhi. These three people decide whether a person has to be transferred. Let's say there is an officer. If this officer has to be transferred from one department to another, from one place to another, who will decide it? It is this particular authority which will decide on the basis of the majority. So there are three people ultimately. On the basis of majority, they will decide whether a person in Group A or Group B will be transferred to a new place, will be transferred to a new department. Now let's understand the logic. Now this person is transferred, or let's say if this person has to be suspended temporarily because there is an allegation against this particular person that he is involved in a series of corruption charges. So again, it is this particular authority. Now this person feels that his right is getting violated, principles of natural justice, every person will have to be heard. It is not that this particular authority suspends him and he has no other right to voice out. So what would happen? He would have a natural right. He would also want to voice out his grievance. So what we need is an appeal provision. So the National Capital Services Authority will define all the procedures with respect to the transfer, with respect to the appeal, with respect to the natural justice principle, and all of this will be decided by the National Capital Services Authority. Ultimately, they will make the recommendation to the Lieutenant Governor. The Lieutenant Governor will have to listen to it. But what if there is a recommendation given by the National Capital Civil Services Authority and it is not accepted by the Lieutenant Governor? So in this particular case, the Lieutenant Governor will become the ultimate authority, and whatever he decides will be final with respect to this legislation. Now the important pointers that we have to know is, what is the view of the government, which happens to be its advantages, and what are the concerns voiced by the opposition political parties and the larger repercussions to Delhi. First, we have to understand the viewpoints of the government. What has the government said? The government has said and has made it very clear that when it comes to the National Capital Region, we have the embassies, you have all the international diplomats, you also have international organizations as well. And when you look at the objective of 239 AA, it is very clear that police and public order and land is with the central government. While this is the major objective, Delhi happens to be the national capital. Interest of the nation along with the interest of the Union Territory of Delhi in the administration of the capital has to be taken, because it is very, very important to safeguard Delhi. And as a result, who will safeguard Delhi? It is these administrative personnel, and they have to directly listen and they have to coordinate with all departments of the central government and the Home Ministry as well to upkeep it. What they want is that they want it to be under the control of the Lieutenant Governor in case there is any clash between the National Capital Services Authority and Lieutenant Governor, which is why they say that the ultimate authority will have to be the Lieutenant Governor. Added to it, what we have is quasi-federalism in India. It is not that states are completely independent like in United States of America. We do not have a fixed federal structure, which means that states also have powers, but at the same time central will have more powers. So with this particular power, and since Delhi is the national capital, we have to control it, is the viewpoint of the central government. Now we have to look at a couple of concerns. What are these concerns? One, what we have to look is through the Supreme Court judgment. The Supreme Court had come up with what is called as triple chain of accountability. What is this triple chain of accountability that the Supreme Court had come up with? When it comes to triple chain of accountability, we have the civil servants. The civil servants are ultimately under the control of the cabinet. The cabinet are under the control of the legislature, and ultimately the legislature are under the control of the people. So basically the triple chain of accountability, which the Supreme Court had reiterated, that services will come under the state legislature, that is, they would come under the cabinet will fall under the legislature, and they're all accountable to the people. This is getting violated in this particular case. In fact, the Supreme Court had also made its order. It had also reiterated that it is the state government which is supposed to listen to the queries, the grievances of the officers, and ultimately it is they who need to have the control of the services of these administrators, that is the executive. But unfortunately, in the present situation, this triple chain of accountability is getting violated. The order of the Supreme Court is getting violated. This raises a question of the division of power between the central government as well as the national capital region. So basically the whole concept of division of powers, which ultimately goes on to say that all powers will be with the legislative assembly, will be with the elected government, is not taken up, because The central government feels that it is the national capital region. This also violates the basic feature of the Indian constitution, which is federalism. So when we speak about federalism, we know for the fact that federalism is the basic structure doctrine. So it is part of the basic structure doctrine. So you have the central government at the top, the state government at the bottom. So what we have is a clear-cut hierarchy, and we also have powers which have been accorded to the central government and the state government. But in this particular case, despite they elected by the people, they are the representatives of the people, they are not able to take control of the services. This ultimately means that this very idea of federalism is also getting violated. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says stifling dissent. This article basically is important from the international relations perspective. What is this article speaking about? This article is speaking about the politics of Pakistan and its likely repercussions to India as well. What is the context? We have Pakistan's former Prime Minister Imran Khan, who has been arrested this time after a conviction in a case involving misappropriation of official gifts meant for Tosh. When it comes to Pakistan, what exactly happens? There is a very important quote that you can also quote in your exams as well. It clearly goes on to say that when it comes to Pakistan, every country has an army. So we have an army, United States of America has an army, every other country has an army. But when it comes to Pakistan army has a country, quips Shashi Tharoor. So basically what exactly happens in Pakistan is democracy is just a myth in Pakistan. Everything is under the control of the Pakistan's army. In case you are the civilian government, you happen to become the prime minister of the country, you have to toe the line of the army in Pakistan. If there is any issue that you cause a disturbance to the Pakistani army, you question their authority over the administration of Pakistan. In that particular case, you would be immediately be thrown out and you would not be the prime minister or whatsoever in Pakistan. So the present situation is similar such situation where in the past we have had former Prime Minister Imran Khan question the credibility of Pakistan's army. He throws questions to Pakistan's army. He was not okay with army postings that have been taken by the army, and added to it, he also had anti-US stance as well, and he was not able to control the economy. But the major point is he had a major tussle with the army because he questioned the army's postings. Couple of cases spiraled against him, and ultimately he is taken out. Indirectly, it also means that there will be more charges of corruption on Imran Khan, and that is why he was convicted by the trial court, and the trial court feels that he has misappropriated official gifts meant for Toshkhana. Now the question is, what is this Toshkhana? This was initiated in Pakistan back in the year 1974. This happens to be a department under the administrative control of the cabinet division, which basically stores all the gifts, expensive items received by the public officials. Let me elaborate this concept for you. Let's say, for example, there is a Prime Minister of Pakistan or any other public official. Since he is wearing the coat of public official, whatever gifts that he receives as a public official, the same will have to be given to this particular department. It has to be a transparent process, and he has to be accountable as well. In case he does not give the information, in case he is not accountable to the gifts that he has received as a public official, in that case, if he has designated himself as a public official but has not given out information about the gift he has received and has hid this particular information, and on an investigation, if they are able to prove that all these are not given to the department, he can be thrown behind bars. According to this particular legislation, the maximum imposition would be for about 3 years. So the Islamabad trial court handed down the maximum sentence for the offence to the Pakistani Prime Minister, who was charged with 3 years in prison and a fine of 1 lakh. So because he's been imposed with this particular imprisonment, he would not be able to contest in the upcoming elections in November because he has been imposed with a penalty and he'll be thrown behind bars. So the question is Is it the first time that former Pakistani Prime Minister has been convicted? No. There have been couple of issues in the past as well. He has been convicted previously as well. In fact, when it comes to former Prime Ministers, in case they are not in good terms with the Pakistani army, they will be thrown behind bars. That is how Pakistan operates. Pakistan army operates in Pakistan. So this is not just restricted to Imran Khan. We also have former prime ministers like Nawaz Sharif and Shahid Khan who were also put behind bars as well. Now in the present situation, because he had questionable because he was questioning army postings, he also had anti-United States of America stance. He was not able to control the economy as a whole. Army did not take him lightly, and ultimately through an indirect embroil, through an indirect military coup, they have removed the Pakistani former prime minister. This also sends out couple of messages as well. What are those? One, whenever you have the prime ministers who are elected, and ultimately they hold that particular position. Now if this particular person is thrown behind bars, there are people who would follow him as well. You would also have followers as well. These people would not take it lightly. So when former Prime Minister Imran Khan was convicted for the first time, arrested, there were large scale riots that took place in Pakistan. But he is now convicted for the second time. But now army is able to silence the public expression, which means that they know how to silence the people as well. They are able to understand the feelings of the people, and ultimately they also know for the fact how to silence them as well. In democracy, it is a matter of right that you would be able to throw your voices against the government. But in this particular case, despite them, because their leader was arrested, they are not able to do it because army has been able to silence the public expression. This has created a sharp divide in Pakistan, and as a result, people, companies, organizations which are wanting to invest in Pakistan are not investing in Pakistan, and this is beating the investor confidence. We know for the fact that as of now, there is a large scale economic crisis that is prevailing in Pakistan. And if there are no investors who come and invest, there will be lack of economic activities, employment opportunities will not be generated, GDP will be continuously going down, and as a result, Pakistan has to toe the line of United States of America or China and ultimately start asking money from the World Trade Organization and start asking money from the World Bank as well. So this ultimately means the economy will go down, and this will create a ruckus in Pakistan. In fact, formerly you also had one of the ministers in Pakistan who had also asked people not to drink tea as well. Why? Because Pakistan imports a lot of tea, and ultimately he had requested the people not to drink tea because they wanted to reduce on the imports from another country. Such is the state of economy when it comes to Pakistan. How will this impact India? Why should we have a keen procedural look when it comes to Pakistan? That is because this could escalate the cross-border tensions. Whenever there is riot-like situations, instability or internal turmoil in Pakistan, what would happen? There will be focus explicitly on the internal turmoil. It is during this particular period what we will have is the cross-border tensions. These terrorists will start infiltrating along the Pakistan occupied Kashmir. They will enter India, and this will continue to increase the terrorist activities in the Indian Kashmir. And at the same time, what we will have is the peace process which will also be disturbed as well. We have track 2 diplomacy where people will also be involved as well. So in this particular backdrop, when there is internal turmoil that is taking place, the peace process will also stop. So what is it India will have to do? India will have to have a keen look along the border areas, make sure that there is no infiltration, and continue with the peace process and back channel diplomacy is what is this article all about. Now let's look into the next article. This article here is speaking about LK99. There are about 2 articles. This is important from the science and technology perspective, and this LK99, remember, is very important from the preliminary examination point of view. What is this LK99? This happens to be with respect to the superconductivity. What is LK99? It happens to be a gray-black polycrystalline compound that is potentially a room temperature superconductor. Superconductors, if they have to become superconductors, what it will require is excessive temperature as well as high pressures, because they have to show zero resistance to this particular idea. But in this particular case, if it is done at room temperature without excessive temperature, without excessive pressure, that is what is called as the LK99. So basically LK99 happens to be a grey black polycrystalline compound that is potentially a room temperature superconductor. It is said to have a hexagonal structure that is slightly modified from lead apatite by adding small amounts of copper. So remember, when it comes to LK99, what is it? It happens to be a room temperature superconductor. When it comes to the superconductors, they are basically used in the magnetic resonance imaging, they are used in the quantum computers, they are also used in the nuclear fusion devices as well. But these superconductors that we are speaking about only work in low temperature. I'm sorry, it is not high temperature. I'm extremely sorry, it is low temperatures. So superconductors work in low temperatures as well as very high pressure. Because they work in very low temperature as well as high pressures, that is why these will have to be superseded with what is called as room temperature superconductors. So the room temperature superconductors is what is called as LK99. When it comes to the superconductors, they basically show four kinds of effects. What are these? One is called as the electronic effect, second is called as the magnetic effect, third is called as the thermodynamic effect, fourth is called as the spectroscopic effect. Remember, these are very important from the preliminary examination point of view. They might ask you a question with respect to the superconductivity, which of the following effects can be seen? Electronic effect, magnetic effect, thermodynamic effect, spectroscopic effect. So what we have to remember is that all these four effects can be seen when it comes to superconductivity. So remember, superconductivity, it has two important parameters: low temperature, high pressure. And if we have to design them according to the existing conditions, it is an expensive affair and it is too difficult to manage as well. But if it can be done in room temperature, then it will save a lot of expenses. So what are the applications? Using superconducting materials, energy loss from the generating and transmitting electricity currently is an immense challenge, could be eliminated, thereby slashing costs and reducing emissions. Wind and solar power could be stored indefinitely. Battery life could be extended for laptops, phones, electric cars. More tantalizingly, nuclear fusion, the long elusive source of carbon-free baseload energy, could start to look commercially viable as room temperature supercomputers enable smaller and less costly reactor designs. These are some of the applications with respect to the superconductors. Now let's look into the next article. This article here is speaking about the State Human Rights Commission. We have one of the important laws, which is the National Human Rights Protection Act of 1993, which mandates the establishment of a state level Human Rights Commission. So when it comes to the Human Rights Protection Act, we have the National Human Rights Commission, which will be established at the national level. We also have the State Human Rights Commission, which will be established at the state level. What is the work of the State Human Rights Commission? Get involved in any proceeding under allegation or violation of human right pending before a court with the approval of the court, inspecting living conditions of the inmates in any jail or any institution under the control of the state government, review the safeguards provided in the constitution or any other law for time in force to ensure protection of human rights, review the factors that inhibit the enjoyment of human rights. So all those areas where people are not able to have genuine human rights addressed, that will be taken up by the State Human Rights Commission. Undertake and promote research and awareness program in the field of human rights, promote human right awareness through literacy campaigns, publications, seminar for the protection and safeguards available under human rights practice, encourage involvement of non-government organizations and individuals for expansion work in the field of human rights awareness, perform any other function that may be considered necessary for the promotion of the human rights. These are some of the functions of the human rights. As part of the assignment, you have to put on the comment section who is the chairman of the State Human Rights Commission and how is he appointed? What is the term period of the chairman is what you have to put on the comment section. Now let's look into the next article. This article here is speaking about Red Sea. As part of the preliminary examination, it is very important. What you have to put on the comment section is the number of countries in and around the Red Sea. So remember, we have Red Sea, we have countries located in and around Red Sea. Which are these countries which are present in and around Red Sea is what you have to put on the comment section. So this is it for today. Thank you for watching, and please do like these videos, comment on our videos and share it with your fellow aspirants. Thank you for watching. All the best.